Elon Musk trying to reincorporate Tesla in Texas following a Delaware judge's ruling invalidating his $56 billion pay package. Joining us right now with the legal implications of a move from Delaware to Texas, Tulane Law professor Ann Lipton. Ann, it is great to see you. Before we get directly to the Delaware to Texas move, I just want you to weigh in, if you could, on the judge's decision. Did you think it was the right decision or the wrong decision?
I think that it was a sort of straightforward application of settled principles in an absolutely extraordinary situation. Normally, you don't have problems with the board awarding a CEO pay. The board has a great deal of discretion to do that. But because Tesla's board is so unusually personally tied to Elon, the court held that you can't really trust their judgment, and you can't trust the judgment of the shareholders who voted in favor because they weren't given full information. And that left it to the court to have to decide whether this pay package was appropriate.
And can I ask you a separate part? I want to break that down into two parts. I think that you and I and reasonable people could agree that this board doesn't appear to be as independent as you'd like it to be. I think we could agree to that. What's less clear to me is whether you believe ultimately that the entire shareholder base effectively are such sheep that they all voted in favor of this transaction because they believed that the board was independent, and it was their independence and blessing of the transaction that is what ultimately sold them on the deal.
Okay, see, I think that's a really great question, because the fact is that on one hand, you sort of we know this company is in the news all the time. We know exactly what Elon's relationship was with the board. Everybody knows it. So was it a secret? On the other hand, the proxy statement really was misleading, and she found it was misleading fairly convincingly in terms of what happened and what the relationship was. So settled principles of law would not be, but don't we all know? You would look at the proxy statement.
I don't disagree with you. The question is then what is the ultimate answer to the fundamental question, which is, what do you do about it, right? I mean, ex post facto.
Right. And so what you do about it, therefore, under Delaware law would be, well, you can't trust the shareholder vote. So now the court has to step in. And she acknowledged that he has performed amazingly for Tesla shareholders. That's absolutely true. The question is whether he needed this additional $56 billion in order to do that, given that he already owned the 21% of the company. He was going to make $10 billion for every milestone he hit, regardless of this additional pay package. So the question of
just take it back to shareholders again? I mean, if the information was not there first time around, can't they just take it to shareholders again and get another vote? Because I have a hard time thinking that these shareholders would say no for getting.
Oh, I think today you would say no because you've already had the performance.
Well, that's exactly it. Because they've already had the performance, even if they voted yes, it might very well go in a different legal category, a legal category called waste. They're giving away assets for no reason. And that requires a unanimous shareholder vote.
So let's talk about the prospect of Elon Musk moving the company to Texas, and also the prospect that, I don't know if you think this is true or not, do you believe that other CEOs look at this particular situation and say to themselves, Delaware is no longer friendly to business, or do they say this is just such an idiosyncratic and wild and different, unique case that we're very happy to be in Delaware and we like the legal system there?
I think that is definitely what their lawyers should be counseling them. Whether or not CEOs follow Elon Musk because he's a role model is a different question. So I don't know what those internal decisions are. I do think this was a very idiosyncratic decision for a highly idiosyncratic board. So I don't think CEOs need to panic. That said, I think Elon Musk serves as very much their sort of guiding light as what they think, or often what they think they should be doing. And so they may very well be influenced by that.
How do you look at the corporate legal landscape in Texas as opposed to Delaware?
Well, the thing is that it's very hard to tell. The advantage, or one of the advantages that Delaware has, is that it's had a system of corporate law that goes back over 100 years. It's dominated the market. So we know what Delaware law is. We know what procedures are required. Other states have more trouble competing, in part because we just don't know. We don't know what their courts would decide. But we do know a few things. I mean, obviously, the state has been sort of loudly encouraging Elon Musk to reincorporate there. They're proposing these new business courts that will essentially be very much under the tight control of the legislature. The judges there are up for reappointment every 2 years, the governor and the legislature. And the courts will sit with juries. It's possible there will be jury trials, unlike in Delaware. So I think Musk may think that that's a more hospitable environment for him to handle any dispute.
And final question: What do you think the right answer is on the previous comp package? Because if it effectively gets sort of terminated based on this judge's opinion, that creates and would somehow require a vote ex post facto, as we just discussed. I would imagine if you were a shareholder today, you might not vote for it because you had no idea. I mean, one of the things that's so fascinating about the deal that they made was at the time, it seemed completely and wildly improbable. And in fact, the company, a lot of people thought the company was worth zero at the time. That's why the deal was made. But then if you can, this happens, and here we are.
Whether it was the right answer, I mean, you know what? I'm really uncomfortable weighing in. I'm really glad I don't have to make the call. I think Chancellor McCormick's opinion is extremely persuasive as she lays out what all the problems were with this package and how it just isn't clear that something of this size was necessary to motivate Elon Musk, given that he already owned 21%.
The other thing that I didn't understand about that is this idea of necessary. There's a lot of things that are not necessary. I have complained bitterly about lots of different comp packages. I actually think, by the way, this comp package on a relative basis, in a sort of pay-for-performance way, is actually a much more justifiable, arguably enough, than a lot of other pay packages, which seem completely unnecessary. This was somebody who had other options. People forget that in terms of what a market is. This was a guy who owned other businesses and was thinking about stepping back at that time, oddly enough.
No, she found as a factual matter he wasn't. He offered testimony that he absolutely was not going to leave Tesla. So that wasn't even on the table.
No, it wasn't about leaving Tesla. It was about what the role that he was going to play at Tesla was going to be. I remember this vividly because I remember reporting on it.
Yeah, and one of her concerns was that the board was concerned about that too, but thought about requiring him to remain CEO and didn't even do that. So it's just odd that, if he has 21% of the company, is he really going to step back? I mean, he's not the CEO of Twitter, but he still runs it functionally.